Do you want me to present slides also, or it's enough if I just
Yeah,
do the?
if you wish to, you can do so. Basically,
Okay.
it's a session for addressing the queries of the students.
All right. So
Unfortunately, the students are not actively joining in, sir.
okay.
But if you wish
Anyway,
to
so
present,
I'll just give the brief presentation.
yeah, sure, sir. I will give you co-host right so that in case if you want to present anything, you can do that, sir. 1 second.
Just a minute. I take those
Yes.
slides.
Yeah. So we are live on YouTube, sir.
All right. Just a minute. Give me a minute. I get
Sure.
to those slides.
Definitely, sir. Definitely, sir.
Okay. So I can share the slides now.
Yes, sir. You can share the slides, sir.
Okay. Let's see. All right. I believe that these slides are visible now.
Yes, sir. Slides are visible, sir. So can we start, sir?
Yes. Yes.
Sure,
So
sir.
basically, this is the course on law of sea and maritime law. As a matter of fact, in this course, we have covered very majorly we have covered law of sea, but only very minor aspects on maritime law, which probably will be covered in the next part of the course whenever we conduct that one. So how it starts? It starts with the basic conference that was initiated in the year 1958. So prior to the year 1958, that is Geneva Convention on Law of Sea. Prior to this convention, also there were attempts made for evolving any such law of sea, but that was mainly on a bilateral basis. And primarily the customary practices of European Union, or the present day European Union, or in historical terms, I can say that the European nations, they were actively involved in highlighting their customary practices. For example, uh, the Rotterdam, you know that Rotterdam is presently very famous for this Rotterdam Convention, and then Hague is another such place which is famous. So nowadays we term them as a Hague Visby Rule, Rotterdam Convention, Hamburg Convention. So all that, they acquired popularity because during the earlier times they were quite active in setting their customs or deciding their customs as the rule and principles based on which the law of sea can be formed. But since the European nations, they were at war with each other because of the naval supremacy. And moreover, by this time, after the formation of the United Nations, the countries across Asia and Africa, they got independence. And now the international law itself became a big platform for discussing the agendas that are related to uh, countries all across. So similar was the situation with regard to the issues related to sea, and therefore it was realized through UNICLOS, that is United Nations Convention on Law of Sea, that there must be uniformity based international law or international law principles governing all the states in the matters of sea. So when we talk about the Geneva Convention, at that time it was at a very nascent stage. Not much of the issues were discussed. For example, they were trying to figure out what will be the territorial water limitations, or what will be the contiguous zone limitations, to what extent the states can be allowed to use exclusive economic zone, but they could not agree on finalizing the extent of the boundaries. But there was one thing very clear, that these kind of zones will be created for determining to what extent the coastal states law can be extended, and what will be the nature of that coastal states laws. Because as you know by now that the nature of the coastal state laws varies after these zones, like in every zone. For example, what we term as a territorial waters, the nature of the coastal state laws are of different nature. Further, when we talk about the contiguous zone or the exclusive economic zone, they are of different nature. So this was how it was working. And then later on, after this 1958, another convention was held in 1960, and that could not bear much results. So finally it was in the year 1982 when what we term as UNICLOS 3, that was framed, and that became the guiding principle for all the signatories to start with the law of sea. Earlier, as there was a big gap or big void in the international law concerning the law of sea. So from 1982 onwards, we got some very specific document that dealt with the different zones on the law of sea and different rights of the coastal states pertaining to the law of sea. Now, mainly we start with, as you can see in these slides, we start with this. Uh, these are like, I'll come to this issue. For example, we start with territorial waters. Just a minute, I can show you here. Uh, so this is about the territorial waters. Uh, Firstly, we try to find out what we mean by the internal water. So internal water is somewhat that is part of the water area that is inside the coastal region. That means there is a coastal boundary, and uh, from baseline onwards, from baseline to seaward side, we consider that as a territorial waters, and from baseline to the landward side, if there is a water, then we consider it as an internal waters. So we start differentiating between internal waters. Why that differentiation is essential? Because from internal waters, we have to demarcate that from what point we start with the baseline areas, and from baseline onwards, we determine the territorial waters. Let me show you this. Just a minute. Yes, this is baseline area. So, how it is defined, the drawing of state baseline must not depart to any appreciable extent from the general direction of the coast, and the sea areas lying within the lines must be sufficiently closely linked to the land domain to be subject to the regime of internal waters. It is further defined under Article 8 of the UNICLOS, that is United Nations Convention on Law of Sea, and it covers not many areas like the port, then low tide elevations. So all that are part of this baseline. Here you can see the boundaries between the states. So this is state A, and uh, the perpendicular line that are drawn from here, we start the baseline area, and any such water body like this way, you can see the water body, that is all the internal waters. We have discussed this in courses. Now there can be various kinds of baseline, because depending upon the nature of this boundaries between the land and sea. So it's not always there is a state baseline line baseline, state baseline, but it is rugged, or it is semicircle, or it can be like curvy kind of baseline. So in that case, how we draw the territorial water area, that becomes questionable in terms of the legal rights. So there you can see in this illustration that the straight line is drawn, like here also the straight line is drawn, and furthermore, uh, the water area beyond this becomes part of the territorial waters. So here you see this is the territorial sea area. Now, one more particular thing about the territorial sea area is that the foreign vessels, that is the ships that are coming from abroad, they do claim innocent passage. Now, what is the question? What is questionable here? That territorial sea is basically sovereign extension of the coastal state. That means the coastal state does have the sovereign rights to the extent of territorial sea waters. Sovereign right here means even a flight or an aircraft wishes to cross that area, that is territorial area, it need to seek the permission. So all the rules that, or all the laws that are applicable to the coastal state or inside that land area are equally applicable to up till the extent of territorial sea area. So that is one interesting thing. But with regard to the innocent passage, if a foreign ship declares itself to be innocent, innocent means it cannot create any kind of harm to the coastal state, and for certain exceptional reasons. For exceptional reasons means if someone's life is in danger, someone who is on the ship, his life is in danger, or the ship is in urgent need of repairment. So in that eventuality, they, after declaring that they will not do any harm to the coastal state, that is declaring themselves to be the innocent, they can seek the permission to enter the coastal state area. So that is what we mean by the term innocent passage. So here now sometime this innocent passage is stopped depending upon the relation between two coastal states. For example, here during the Litte period, the innocent passage for this region, that is, you can see here the Sri Lanka and Gulf of Mannar, they are very close to the Indian waters, and seeking and the movement of the ships without seeking the permission from the Indian side, or if the Indian vessels they want to move to the other side, they need to seek the permission from Sri Lanka government. So when the relation between the two countries were strained because of the Litte problem, so at that time, innocent passage was denied. So this is an example here. Now this is Strait of Dover between England and France, and they are that is the English Channel. And when English Channel becomes the Strait of Dover, then it gets narrowed down, and the innocent passage, claiming the innocent passage here could be risky. But since England and France they are not uh, having strained relations, so there won't be any problem by any of the country giving innocent passage to the desired ship. So in this course, we have also dealt with other cases like Qatar versus Bahrain. There the boundary dispute was, or the not simply the boundary dispute, but also concerning certain islands that were claimed by Bahrain as their part, but actually they were decided in favor of the Qatar. That is also a very interesting case discussed in this course. And other interesting case is the boundary division between India and Bangladesh, because India and Bangladesh they have the porous borders, and the river waters that is very unpredictable, because every year they have floods, and it's not simply the floods, but every year these tributaries or the rivers they change the course, and sometimes they are ending up in the sea through the Indian side, and sometimes they are ending in the sea through the Bangladesh side. So it is very difficult to decide what is the true extent of territorial boundaries. And in this case, the certain exceptional methods have been adopted when the territorial boundaries between India and Bangladesh were settled. So that is another interesting case discussed. Also, the fisheries issue is very pertinent, mainly because fish is a very rich source of protein, and European food habits are very much dependent upon the fish. So, Iceland versus UK is a famous fisheries case where Iceland voluntarily and without seeking any such uh, permission, or let's say without seeking the consent of the other parties, extended its fisheries jurisdiction, which was challenged by the United Kingdom. But Iceland further kept on the status quo. That means it has not withdrawn from that level of fishing or that region of the fishing, stating that that is based on its customary practices or the practices that were prevalent even prior to the formation or the creation of the laws. So it can't be that the Iceland will change its customary practices every now and then. So since law of sea is very much based on the customary laws or the customary practices of the various nations, so this was accepted by the court. International Court of Justice decided, but then International Court of Justice also uh, framed the right in different order. Like it said that Iceland, being a coastal state, does have the preferential right, but in United Kingdom also has the secondary right. Although those secondary rights belonging to the United Kingdom, they are subject to the conditions settled by the Iceland. But in any case, Iceland cannot claim the rights as absolute rights belonging to it, and can refrain any other country from using this area for the purpose of ship fishing. So these are like the some of the interesting cases discussed in the course, and I hope you might have find interesting. So far as the contractual part is concerned, that means the rights of the parties in terms of the contract that is formed when the ships are used for the purpose of carriage, or the law on the carriage of the sea. So that will be covered in the other course, and that has been very uh, minorly dealt in this course. So I hope you have find this course worth knowledgeable, worth knowing the facts about the sea. And in case you do have queries, I can send my email address, and you can write the questions. Or in case you are requiring any specific case material, please do let me know. I'll be there to help you. Thank you very much. So this is my email address. Thank you.
Yeah. Thank you so much, sir,
Yeah. So if you have
for
any
giving a brief overview of the course. Yes, sir, we got a few queries, sir. I will just share my screen. Can you close your share screen, sir, so that I can share the screen and
yes,
show you the questions which we got?
yes, sure.
Yes, sir. Just give me a second, sir. We got a few questions. Are you able to view my screen, sir?
Yeah, can a coastal
Yes, sir.
state board a foreign ship in
Board
its
of
territory?
foreign ship in its territorial waters for civil jurisdiction matters without breaching international law? That's
Can
the
a
first question,
coastal
sir.
state board a foreign ship in its territorial waters for civil jurisdiction matters without? Yes, that's good. Now, the question this gentleman has asked, this is related to maritime law. Yes, the state can does so. The difference is like uh, registration of the ship. So there is difference between ownership of the ship and the registration of the ship. Ownership of the ship belongs to, or we define it like that, ownership is based on the citizens who are owning the ship. Like if four or five citizens, they have collectively purchased the ship, so then it belongs to, let's say, it ownership is with the Indian people, so the ship, we can say the ownership is with India. But that does not mean it gets the right to registration. So firstly it has to register itself, and despite Indian ownership or ownership of the Indian citizens, it can get itself registered any place in the world. All right. And to the place it will get registered, it will carry that flag. So, and once it has carried that flag, that means the law of the country where it is registered, that will be applicable. Now, your question is, can a coastal state board a foreign ship in its territorial water for civil jurisdiction matters? Of course, when, let's say, an Indian firm wants that the ship should carry its goods from, uh, let's say, to Singapore, all right, and in the Indian waters, it's not that only Indian ships or the ships that are carrying Indian flags, only they are stationed. So the ships that are belonging to the countries belonging to that are registered in some other countries, they are also stationed. The ships that are carrying Indian flags, that means they are registered in India, they are also stationed. So it is permissible. And there is a very famous case also. I can, if you share the email address to sir, so I will share you that case also. The only thing is that the duties the foreign ships will have to pay is a bit higher than what the Indian ships will have to pay. I mean, if the ships that is carrying the Indian flag, this means that it is registered in India. It is not necessarily that its ownership is also with India, because it can be that the person or the company is a Korean company, but the ship is registered in India, so it's carrying the Indian flag, and then it will have to pay lesser duty in the Indian coastal waters or in the Indian ports. And if there is a UK ship or a ship belonging to any other country and is carrying the flag of that particular country and is stationed in India, then they will have to pay extra duty. That is the difference here. Next is, how do bilateral agreement between India and Sri Lanka impact freedom of navigation rights under unique laws? Now, one thing is that the bilateral agreement between India and Sri Lanka is within the framework of unique laws, and it's basically uh, the special clauses are included. Now, you have stated here, how do bilateral agreement between India and Sri Lanka impact freedom. So that means the specific clauses have been added, and within that specific clause, that means if the ship belonging to any other country wants to enter that area, okay, the area, the coastal area between, or the water body area between India and Sri Lanka, then either of the country is supposed to inform. So why will the ship enter to these coastal areas? So either they want to use the Indian port, or they want to use the Sri Lanka port, or they are in transit area zone. That means they are simply passing through the India, these coastal waters. So in the coastal waters, like if the ship from China simply uses the coastal water to uh, enter to the Andaman Sea, and from Andaman Sea it wants to enter the Thailand area. So that means it's not going to stay in the Indian port or to the Sri Lanka port. So in that case, it will simply inform the coastal authorities of both these countries and then pass on. But let's say if the Indian port is allowing the ship belonging to any other country, and that touches the jurisdiction of the Sri Lanka port also, or the Sri Lankan territorial waters also, then the Indian authorities must inform that we have asked this and this ship to enter the zone, our jurisdiction. So that might be like it follows your path, or it firstly enters your territorial jurisdiction and then finally enters. So in that, on that basis, that negotiation can be done. The only thing is that it won't be as free as it is expected under the unique laws. Reason being, because the special uh, security related uh, provisions are added, and that are permissible under unique laws itself. The third question is, what are the major challenges in forcing Indian Maritime Zone Act, especially with regard to the foreign vessels? Now, this is a very big question. Firstly, I would say here there are one major challenge is that mostly the ships, they are belonging to the foreign companies, and they want that uh, the standards that are like the standards that are stated, or they are required to be met in the Indian ports, they must be of international, like they must be internationally calibered, or you can say that they should follow the international rules. So sometimes this does not happen. Like there is a famous case where the Indian government passed a law, thereby it was promoting made in India concept. It's very recent case, and because of this made in India policy, they were waiving off the duty to the ships that are manufactured in India. Just now I have stated to you, the flagship is different thing, and The ownership of the ship is different thing, and make in India is different thing. So what they were doing, that was only to motivate this made in India program, and more shipping companies, they should use the manufacturing line of the Indian companies, manufacturing line for manufacturing the ships in India. So that was something challenged by the foreign ships. Also, with regard to the port duties, that is often challenged, that there are numerous duties that are levied on the ships, foreign ships, so that sometimes can be a bit complex here. And even more important is whether we are, to what extent we are following the environmental guidelines. If you see the European Union, they are very strong in imposing these environmental guidelines, and vis-a-vis the Indian this coastal laws are concerned, they are still not very strict. The example is, there was a one Clemenceau ship that was sent to this Anand port in Gujarat. Okay, and that was violative of the Basel Convention, and that was actually the decommissioned ship. So Clemenceau, it was certified by French. Clemenceau was the French ship, and it was certified by the French that it does not contain much of the asbestos. Basically, asbestos is a very injurious substance, and at the time of it's when the ship is let's say de-installed, or you can say the ship is broken. So in that respect, the lot of asbestos dust, you can realize that when it enters the lungs while these workers are breathing, so that do choke the lungs of those workers. And when the suspended particles of these asbestos in the air, they are inhaled by the workers there, that is very threatening, life threatening. But the French government has certified that this ship does not have much of the asbestos, and it has been removed. Okay, but that was not the true, and neither does the Indian authorities verified what is the its present status. So they allowed this decommissioned ship to be sent to the Anant port, that is in Gujarat. But later on, it was found by the environmental bodies in Gujarat that this, because there were several such incidents, and that has risked the life of the workers there, that uh, it was actually not in appropriate proportions. The asbestos was not rightly removed. So they challenged it, and as a consequence, this Clemenceau ship was returned to France. So this is one such example that we must be very particular, because it's a great threat to marine life. It's great threat to human health and life, uh, and also the plantation vegetable. So although it may not, the effects cannot be realized in let's say short term, but if you see, or if you analyze the long term consequences of these loosening the environmental norms vis-a-vis the carriage through the sea route, then they can be really very devastating. So that is one such issue we must be very very particular. Another is, now the European Union is facing the challenge with regard to the sabotage of this cables, the seabed cables. They do use it for the internet purposes, and that has been broken, or that has been sabotaged, that has been cut by they claim as Russians or their adversaries. So in that respect, how far we are protective with our the coastal resources, or when we are using these for the purpose of cable or uh, oil pipeline, so that must be strictly configured so as to make these ventures very successful and risk free. So this was what we can say, but these are very big questions, especially the third question that you have mentioned, and it will require a very big discussion. But anyway, I can just give you the overview with these two main points. One is the environmental concern, and then the imposition of the customs duty on the ships that are coming from abroad. That sometimes is discriminatory in nature. So these were the answers to these queries. So I have shared my email address to Sir Murli sir, and whenever you feel like asking me, please do write, and I'll try my best to answer your queries. Thank you very much.
Thank you so much, sir, for answering those queries raised by the students through the Google response sheet. Uh, And then the examination is on 25th of April, sir, for our course. So would you
25th
like to
April.
discuss 25th of April? Yes, sir. So would you like to discuss about what questions they will expect, whether it will be a subjective questions or objective type
It's
questions?
objective, basically objective, 4 questions and this tick mark. And mainly they were from the courses. Those I think we have discussed much in those slides
Right, sir.
or the presentation that has been recorded in different
Right,
modules.
sir.
So you can,
Sure, sir.
yes.
So for our course, 130 students have registered for the examination, sir.
Okay,
So
okay.
you can wish them,
Good luck.
and then
I
we can conclude.
definitely, yeah, yeah, sure,
Yeah,
sure.
definitely, sir.
And
So
I'll be
can
very keen to see their answer sheets. And in case they want to discuss even after that, we can have some discussions.
yes, sir. There is a discussion forum where they can post the queries, sir. So that is one option, and another option is there they can directly write to your email ID as well
Sure. Welcome.
if
I
they have any
welcome.
queries. Yes,
Yes.
sir. So we don't have any other queries on YouTube, and Zoom also one student joined, but later he get away, sir. So can we end the session now, sir? Since there
Sure.
are no queries. Yeah. So
Yes, with
thank you
your
so much, sir,
permission.
for your
Thank
valuable
you. Thank
time.
you. Okay.
Yes, sir.
And
See you,
I'll
sir.
share your email address with that gentleman from Morocco.
Definitely, sir. Definitely, sir. We will help him out, sir, to appear for the examination.
Thank you, sir.
Thank you so much, sir. So I'm going to stop the streaming and close the Zoom, sir.
Sure, sir.
Yes, sir. Bye, sir.